Oh, hello. What's up, guys? You guys might think I'm a dishwasher. No, I'm just a law student. So, what's up, guys? The reason I'm doing this is to raise awareness about our helpers and cleaners. So, please, if you have hired anyone to do your daily chores, and for example, people who clean your cars, who wash your dishes, who clean your houses, please don't stop paying them. Please pay them. And especially if your income hasn't been affected. I understand some people have lost a lot of money, but even if you can afford to pay, please do that. And if your income hasn't been affected and you still haven't paid your help, I hope you get fired. No. Yeah. So, all right. So the next episode is a very special one. I have Mr. Aditya Chatterjee, who is an alumni from my law school, and in the first segment, he speaks about his journey, his time in law school, his learnings, and there's a very nice learning, and you will really appreciate that. However, in the second segment, which is roughly after 30 minutes, he speaks about his views on CAA and the abrogation of Article 370. So I think it's going to be, I hope it's not too controversial because not a journalist, just a law student. Thank you.
Hey guys, maybe I should start a podcast.
No.
No.
Hinduist boys do as we please. My lynch map protected by police. I'm in New Delhi in my Mercedes and my Mercedes full up.
Hey guys, what's up? Welcome to another episode of Fun with Law. And today I have a very special guest. So finally I got someone of stature who doesn't know me personally. So I think that's a big achievement. So he's Aditya Chatterjee. He's my senior from GNLU, and currently he has an independent practice. He went to University of California, Berkley to pursue his LLM. And for what I know him for a little, like I think he's a gem of a person. And so what today's episode is going to be regarding the politicization of core legal issues in terms of Article 370 and the CAA, because Aditya has worked with regard to that. And I recently took his seminar course on political trials, where he gave a huge background about how a lot of landmark legal cases were a result of politicizing the issues with regard to them. So yes, take it away. Tell us about yourself a bit.
I don't think there's too much to say beyond what you've said. So I practice in Delhi now. I went to Berkeley for my LLM. My practice has really seen two phases. The first phase was in Karnataka, where I was in the High Court there. And after that, for the last 2.5 years in Delhi, mainly in the Delhi High Court and Supreme Court.
Tell me, what's your typical week or day like? So you have an independent practice, right? So what is it like now?
Yeah, so even then, I must qualify. My training really is as a commercial lawyer. So I see myself, my core competence is as a corporate commercial litigator. So most of my disputes are really on the commercial side. And your typical day is that you have clients coming in every now and then. A lot of that is in the pre-dispute stage. So you're also planning when it goes into dispute, what really you're going to be doing. Some of the cases are already in dispute, or you need to rush to court immediately. Then those cases have a different approach. But I would say typically it is preparing for cases that are already in court, preparing for hearings that are coming up maybe in the next day, the next couple of days, and meeting new clients and figuring out what really works for them. And that is the business side of my day. But apart from that, yes, I one of the reasons why I wanted to start an independent practice is so that I don't get absolutely limited to one practice profile. I've always been interested in building a wide range of practice areas. So in the sense, I didn't want to do only contracts, only commercial law, or only company-related disputes in the NCLT or NCLAT. And I found that once I went independent, I started doing many more kinds of cases. So starting from labor disputes to constitutional issues that I got pulled into just by chance, That was the motivation behind going independent, and it all worked very quickly. So I would
Yeah.
say my day is a mixture of all of this. It's a very, very complex mix that sometimes I can't handle, sometimes I can handle, but that's how I like life going ahead.
Yeah.
For a
Okay.
long time, the plan was that when I go independent, I would uh, throw myself under a senior and simultaneously try and build a practice. And that
Yeah.
was really because I felt, because I'm not really born and bred in Delhi, that
Yeah.
will be a good way to look at how the career is going to grow. But once I left my law firm and law firm job position and started working independently, I think I got a weekend's break and the first matter came in. And after that, I didn't have, one thing led to another.
Yeah.
So I never got down to applying to senior chambers and joining a chamber.
Yeah.
So it basically got procrastinated. I was lazy, and now I just have my own. I'm just running my own
Yeah.
practice.
Okay. And that's, I think, I'm sure that you are being modest about your competence, but a lot of people are like working and they don't have cases. But I'm glad that that things worked out. Also, so now tell us about your journey. All right. So you have a typical. So you say you never sat for placements. Number two,
Mhm.
you worked quite a bit at Keystone, like not just 1 year. But you worked quite a bit and then went for your
Yes.
LLM. So people generally
Yes.
don't go at that age. And then
Yeah.
you again were at AZB, and I'm sure you were at that position where if you wanted, you could have, gone ahead and gone high up in the commercial world, but you chose your own practice. So what's your journey like? You know?
I think it all starts with why I entered law school to begin with, and
Yeah.
like I think most people who enter law school with some ideal notion of what lawyers do. I really wanted to be this Atticus Finch kind of lawyer who would
Yeah.
just walk into court every day, saving lives, kind of Superman. But
Yeah.
obviously, things get real once you start
Yeah.
going through the drill. And at so once through law school, my interest was really, obviously, on the one hand, I was extremely interested in the subjects itself I found very appealing. So I was not a very exam oriented person, but I deeply enjoyed every class. And even while I was in law school, so the courses that I continued teaching, it actually started while I
Yeah.
was in law school. So I started this
Okay.
in my third year. So since
Yeah.
my third year, incrementally it's been building up. And so when it finally came down to placements, and everyone is telling you that a good law student who's doing well, more or less well, and has decent marks in your subjects, just sit for placements, get a job, and here you have enough time, then figure out life. Why do you want to let go of this? But I think finally, when it came to deciding whether to sit for placements or not, I realized somewhere, I don't know, it was not my first reaction that I'll go sit for
Yeah.
placements and run the race and move into a job. And by then I had interned at Nayak and Sri Kumar, which is, before it became Keystone Partners, the firm was called Nayak and Sri
Oh,
Kumar. Okay,
okay.
so I had interned with the folks who run the firm in
Yeah.
their earlier capacity as people who were senior associates and principal associates at Indus Law. And I again went back to intern with them in my fourth year, by which time they started their own law firm. And then that led to them saying that if you finish law school and you are interested in litigation and you plan to come back to Bangalore, uh,
Hmm.
consider, see if you want to work with us. And I didn't really understand that that was an option then, but I was in my head very clear that if I go back to Bangalore, I want to go and work in the trial courts.
Yeah.
So in the fifth year, the choice was really between, do I start working in Delhi and say join a senior who has a practice in the Supreme Court, or do I go back home and work in the trial court? So that's the only decision I had to make. Once I made that decision, it was pretty clear uh, how I was going to go about it. So the question of sitting for placements was not very high on my agenda. And I decided in 2 years' time, after giving practice a shot, I'll take stock, see how it's looking, and if it looks good, I'll continue. And
Yes.
I wanted to study, at least in some comparative space, where I get a chance to study for the sake of studying. It may not have anything to do with career, but just for the
Yeah.
academic side of it. And finally, in 2016, I was like, "Chalo, time, go for the element." Yeah.
You seem like that's a like I know it sounds like a very cool decision, but I'm sure it's very bold too. You don't do these things, take a stand, like I don't care, like I will just study for the sake of it. But a lot of people like it's I think you
Uh,
need like courage for that. So
Courage, yes, but I'll also say I was in a very fortunate position. See, because I was also speaking to friends and colleagues who were sitting for placements and see the various impediments that you have to account for. Like, say, for instance, I was responsible for family, or I was responsible to make sure that I earned a particular sum of money to keep things going in life generally. I probably wouldn't have this luxury to say, okay, I'm not sitting for placements. I'll just do what I
yeah,
feel like and then go about it. So it's also a lot of circumstance. Circumstance was kind,
yeah,
where parents, family, friends around, no one really said, "Ha, you have to go sit for placements." I had
yeah,
a free hand really. So I think a lot of the boldness of a decision
yeah.
is cushioned by these nice
But I think
circumstances.
that's the I don't know if I would say that advantage, but I think that's a general national law universities culture because since CLAT is an English driven exam, so a lot of kids
Yeah,
come from metros, from upper middle class background, so they generally
yeah,
don't have that pressure to have sit with that pressure.
yes,
So 50%
yes,
people
that's
are
true.
generally just for the we'll see, we'll ride it out, we'll see what we do, things like that.
Correct,
But
correct.
uh,
Yeah.
also just to you know I always ask this question to people because people have very interesting answers to that. What is your biggest failure?
uh,
Yeah,
i I started approaching, I think, practice as a, like, in my head for a very long time I had started assuming that all solutions to all problems in the world are legal solutions. Okay, so I
yeah,
think I had a very blinkered approach to, so any problem that you brought to me, probably say in the last 3 years, I would say, "Ha, you have to file a suit for this." So, uh, so I don't know. My failure
yeah,
was in not recognizing that there are larger things, and the
yeah,
way think I probably not understood the roots of it.
yeah,
And another probably law school wise failure I would say is that. I didn't pay enough importance to uh, reading case laws in their whole. I was a very, so I, until very late, I was like, "Acha, this judgment held so and so, and this is what the judgment
yeah,
said." And what I discovered through work, and I wish I'd done more of it, and which I've been doing since I've started working, is appreciate arguments that were rejected in a particular case.
yeah,
And then more often than not, that gets sidelined. And in our law school curriculum, I don't think the course structure allows for you to get really deep into uh, what didn't work in that particular
yeah,
judgment. And my failure is not getting deep enough. Like,
yeah.
if I'd gotten deep enough into things, maybe I would have saved several years in my learning curve.
No, but probably I completely agree. So I was at SAM this time in November, and so I was in the again IT disputes team because that's my area of interest. So my associate told me to find case law. So my thing is, I used to take the ratio and
Hmm.
I used to highlight the important parts of the judgment, print the judgment, and very nicely prepare a document and give. And generally, at my previous internships, also people really like it what I do. But they said, okay, tell me the facts, tell me the arguments. And I said, I said, okay, do I have to read it like full? He said, yeah. If you are citing a judgment, we expect you to know the whole thing. And I think that was the biggest learning that in law school, especially, we don't know how to read a judgment from top to bottom. I
Yeah,
believe
yeah.
that is what something there.
But I think when you
Or,
say that's, that's more like I'm seeing the silver lining more as a learning. But I'm also trying to fit the definition of a failure where you were just
yeah,
completely trashed out on something. I don't know if
yeah.
GNLU still has it, but we had something called GFL. It was GNLU Football League. Do you still have it?
Yeah, yeah, we have all the leagues now. We have cricket also, or intra, right?
Okay.
Yeah.
Yeah, it
So we
was
have
intra.
all the
So
sports. Yeah.
GFL, I think it started in my third year or fourth year. I think it
Yeah.
was third year. And we used to have clubs. I don't know if the clubs also have changed, but so I
Yeah.
used to belong to a club called the Pirates. And
Okay.
so we reached the finals of the GFL twice, and both times we lost. And my
Yeah.
biggest, I think those are the saddest days of GNLU, where I felt like, I think my biggest failure is that we
Yeah.
didn't win GFL ever. So
Oh my
I
God.
think I would count that as the biggest
Yeah.
failure, and I have very strong regrets about it.
I have this friend called Varun Kasturi. He's also from Bangalore, and he's just exactly like you, like him after losing a football match, like you can't talk to him. You can't talk to him. Yeah, yeah,
I was inconsolable. Like first time was fine, but second time was just too
yeah,
much, and that was on penalty shootout. So it's not now.
yeah.
No, I can't. I don't
No.
think I can get over that. Yeah.
But have you seen the JNLU new campus? Like, have you studied there in the campus?
Yes, my fifth year was there.
Okay. So because now I think it's a brilliant campus. Like whatever's all said and done, like professors and everything is fine, but campus is.
It's a fantastic campus.
Yeah. All right. Now coming on to the next part, of the discussion with regard to the constitution. So in general, you're a constitutional law enthusiast. I mean, you say you have a commercial practice, but I could see your understanding was crazy with regard to that. So, during your political seminar, you said a very interesting line. You said constitution is not just a legal document. It's more of a philosophical and a political document. But the Simon Commission that we protested, that Simon go back and things like that. So essentially that was set up for the Simon Commission that it will study in India for like probably a decade and then recommend a law, which was essentially the 1935 Government of India Act. Now, our constitution, I think probably 60 to 70% of the procedural aspect of the constitution has been picked up from 1935. So what strikes me is that what we protested and the people died while protesting it, today our constitution is based on that. So, things like that. So can you tell me about that political document rather than a legal document part?
Yeah, so it is. So why do I call it a political document more than a legal document? And this, I'm obviously paraphrasing things that I've read in various places, some thoughts that have crept in, and also things that I've heard from a lot of the seniors I've worked with. One is that maybe as a lawyer, and this is something the senior we were working with during the 370 case mentioned. He said, you don't read the constitution like a statute. Say, for instance, you're interpreting the constitution. You're not taking it word by word, letter by letter, and trying to employ legal techniques to split legal hair and decide what is the correct part of the constitution, what is unconstitutional. Rather, the constitution is really an embodiment of experience. It is experience that told us that these are the things that we want to be the philosophical path on which we walk. And that is the reason more often than not, you even have this debate about whether the constitution is a living document or is it, is it imprisoned in time for the time when it was written. And that's more the debate in the US today. And the constitution is obviously evolving. Now, if it is a legal document, obviously the words there have static meaning. But if it is evolving constantly and taking on new meanings, it's because something about experience is going into those words. Something about experience is making it take the shape that it has taken today. And that is why I think it is a philosophy that governs its journey. And and for instance, the Simon Commission Simon Commission, yes, a large part of it went into the Government of India Act 1935. Ambedkar, in fact, deposed before the Simon Commission. There's another interesting commission that came before the Simon Commission, that was the Southborough Commission. I think that was somewhere around 1916 to 1918. I'm not sure about the year. I have to check. And Ambedkar made, again, very, very detailed submissions even to the Southborough Commission. And a lot of it find reflection in our preamble and also in a large part of our constitution. So when I look at, say, the Simon Commission or the Southborough Commission and the Government of India Act, to finally all that went into making our constitution, yes, there are things that were there in those commissions' findings also that are reflected in our constitution. But more important to me is the authors and the identity of the people who were there in the Simon Commission and the authors and the people who made the Indian constitution. And that is why getting out of colonial India was so important for us. Let's say a beautiful, grand, absolutely fantastic constitution, just the way we have it today, was handed down to us by the Queen of England or by the King. Does it still serve the purpose of having the constitution the way we know it? To me, it doesn't. And that is the reason, no matter how much went into the Simon Commission and how much of it we might have taken from the Simon Commission report, the protests against the Simon Commission report and the protests against and the contributions that Indian leaders made to it are equally important. And finally, the whole constitution coming together itself is a huge political event, so far as I see constitutional law. So so it was also criticism of Ambedkar, I think, in the Constituent Assembly debates when it finally got adopted. Some members were found saying that I don't know if we have to congratulate ourselves too much, because we've after all just adopted huge sections of what was there in the Government of India Act 1935. But I think we're missing the point. And the point is that finally we decided that we will adopt a large part of what is there in the Government of India Act 1935. We decided that what are the parts that will be left out. And we decided that we're going to, we the people. Exactly. It may not be absolute representation, but in whatever form, I think that notional symbolism, that it was finally Indians at a table from very different political classes and backgrounds, despite all those differences, came to a consensus that this is it. And that philosophy itself is, I think, very important for me. And it assumes all the more importance today to protect it, that we can't let it just go away.
We'll come to 370 and CA a bit later, but tell me, what are the monumental cases that you've been part of, and how you experience any fun stories you have regard to, any hearings or things like that?
Monumental, I don't know how to define monumental, but I'll talk about cases that have been important to me. And there were two. So while I was at Keystone in Bangalore, I had also started picking up matters that were not strictly commercial. So some of the cases that I had started working on were in the labor law area. So I had started representing a few trade unions. And I had also gotten into one case which involved slum rehabilitation. Okay. And this is nothing to do with the court. So the scenario was that there was a slum in a place called Mandya, which is about 100 kilometers from Bangalore. And some land shark wanted to get rid of the slum because the value of that land had increased manifold. And through some PIL process, he had set up his cases to ensure that the slum is evicted and the land falls to his benefit. The court also was, I don't know if everyone was represented, so the court allowed his petition, all of this was done, and cops showed up at the land to evict the slum dwellers. So this is when they realized that something has gone against them in court because they weren't represented. And through some connection, they got to me saying that, will you take up the cause for this slum in Mandya? More than the case itself, it involved a process about, now what am I to do? So I knew I had to file a review petition to look into the order that was passed. But this
error apparent on the face of record, right?
Yes. And we were taking the ground that the main people who were affected have not been heard. So how it was a funny way it was done, because a slum rehabilitation board was in court who was supposed to speak for the slum dwellers, but they didn't do that. Anyway, the order was passed, but my getting involved meant that I had to meet the slum dwellers. There was no way like everyone would come to Bangalore. At some point, it was decided that I had to travel to Mandya, go visit the slum and speak to whoever is there and to tell them what's going on. And I think this was the most fundamental learning of my career. So I took a early morning train from Bangalore to go to Mandya, and there was someone from the slum who had come to pick me up. And my idea was that I would speak to about 4 or 5 people, explain to them what the situation is, get signatures and leave. And as soon as I entered the place, I found that there was a huge shamiana with microphones set up and chairs lined up. And there were about, I think, easily 300 to 400 people just sitting there, because someone had told them that a lawyer from Bangalore is coming and he is going to solve all our problems. And also, I think the expectation was that a slightly senior lawyer would show up, and I wasn't. I didn't show the experience I was expected to show. But when I landed up there, and it was like a huge function that I was attending, and it was a weekend. So, and they had a mic, so they gave me the mic, and I had to, for the first time, explain law in great detail in Kannada, which is the local language in Mandya. And after doing that, one guy stood up, and he must have been my age and or a little older, and he said, "Why are you coming and meddling in this business? And you're going to say all these things and leave for Bangalore. We are here to face the trouble from the ones creating it for us." And he said, it's only best that you keep whatever you're saying is great, but please take it home. And I was very taken aback because I didn't know what to say. And right then, I don't know, an old woman stood up. I think she must have been in her 90s or something. And she used the most explicit cuss words I've ever heard and asked that young man to sit down. And she just told him, "Look, you don't know what we've done to get this land. No, we built the KRS dam in Mysore. And for our labors, the Raja then gave us this land, saying you live here. No, you don't know what's gone into that. So you don't lecture us now about what should be done and what shouldn't be done. We didn't know that this land was being taken away from us through a court process. Now we are trying to figure out what this court system is to get our land back."
Yeah.
And to me, that said two things. One, the court system itself is so alien to a few people that they don't see it as really the route to justice. So there is a very, very big barrier to justice. And the second is that here is one person who said, "We don't want this trouble anymore." And here was a person who's probably at the fag end of her life, saying that, "Look, please let me speak. I have gone through life to make sure we got this land." It was really the worst way of living. They lived in tin sheds with no bathrooms, but it still meant something to them. And they said, "No matter what, we're going."
It's their home.
Yeah, it's their home. Yes, it was their home. And they said, "No matter what, we're going to fight for this." They didn't even know what it would undertake. They're like, "You tell us what needs to be done, we'll do it." And it was fantastic. They set up a legal support committee. They collected funds. We filed a review petition. The petition was unsuccessful, like very often review petitions are. But what I learned that day about what we do as lawyers and what the system of justice is expected to provide, I don't know. I think it was a reality check.
So I think that's your movie moment. Like everyone. I mean, every time, like especially lawyers, like they think, because by the age of 60, 70, successful honge. Like, if you are in litigation, I'm sure, like you feel if I get a movie, like this is my moment. Well, I stood there and
but the thing is, I couldn't do anything. I was supremely helpless, and you would expect a fairy tale ending to something like this, but we lost in court. I was not there for the argument. By the time the arguments happened, I left for Berkeley, but from what I hear, I think the arguments lasted all of 1 minute, where the court said, "Sorry, we're not interfering." And finally, it is through their on-ground resistance. They have not let anyone evict them so far. So the legal process has not come to their aid. The cops are constantly after them, but just standing together, they've made sure they don't lose their home. So to me, that was a wake-up call.
So also one question about the Constitution.
Yes.
So you have also done comparative study of Constitution, right? You know constitutional law of the US quite well, because I think that was one of your subjects at Berkeley. So I believe US laws are I believe Indian laws are better, just in theory, in terms of how they're written and how they're implemented. But US laws, certain times, like especially their abortion laws and the things that we hear. So do you think even though economically they might be ahead of us, but do you think their legal system is as good as we think it is?
See, I don't want to say I'm an expert in US law, so I'm not going to pass judgment, but I'll just give you experiences I've had. So one of the courses I took at Berkeley was this class called Civil Trial Practice. So the interesting part of the education system there was this class used to happen in the courtroom. So it was not in the university. And the professors, the instructors in our class was a federal judge. And so it used to happen in his courtroom. And the course went off really well. And that was the time I had a very close experience to understand what the jury system works like, how cases get to court and all of that. And a few things I noticed, like 90% of US cases don't go to trial, right? So they get, before going to trial, they get settled one way or the other. And in criminal cases, very often 90% of the cases there's a plea bargaining. So the very often an accused will take the plea, and this happens more so because he's scared that if he goes to trial, he is likely to face a larger sentence than if he just takes the plea. So say for instance, so a very typical method is that an accused who very, very strongly believes that he's not done anything wrong and has a very good defense, but the DA's office has offered you a plea of, say, you go to prison for 3 years, 5 years, if you plead guilty. But if you go to trial, you might be looking at 20 years. More often than not, they take the 5 years. So that is one. I don't know how to balance it out, because I don't know if you can make it a gamble for someone. If justice is supposed to be, if the ends you're supposed to meet is finally to determine guilt or innocence, by putting someone in this lock where 90% cases are not even going to trial, I don't know what's happened. I don't know how efficient the system is.
Yeah.
The second is that once cases go to trial, if there's a blatant error in the trial also, that the routes to appeal are very limited. So it is not as open as the Indian system is. Appeal is very, very restricted to very few types of grounds.
Yeah.
So on the whole, it's quick justice. It's faster, maybe. The process gets over sooner than it would in India. Conviction rates are, on the other side of India, are very, very, very high. But I don't know if it's a good system, because I'm not very convinced, or I don't have a lot of reason to believe that they're getting it right in most cases, because there might be a significant number who are in prison while they should not have been there to begin with. So when the scores got over, our professor asked me, so when you go back to India, will you recommend that the jury system or our system be replicated in India? And I was pretty sure that we shouldn't be doing that.
Jury system in India, you can't do it. That can't happen. Like, genuinely can't.
Yeah, and I saw it. Yeah. I saw its weaknesses in the US also, where but once someone said there, even when you appear before a judge, think of it like you're appearing before a jury of 1 or a jury of 3 or a jury of 5. No, it's a jury nonetheless. So I don't know, but I'm not a big fan of the American criminal justice system, at least.
Yeah, that's right. I think that's a very good insight on because sitting here, it's very easy to say, "Wow, America, amazing," but it's not. Like, you have to look at things more, microscopically. Also, now coming on to the next part, regard to, so I feel there's a concept called purposive interpretation, right? So I believe that Constitution lately has been subject to some next level of purposive interpretation by the central government, where they pick up a provision and then they just, like, for example, what they did with 370, right? So now essentially there was a legal lacuna with regard to the concept called that they will have to take permission from the Constituent Assembly of Kashmir, which has obviously been dissolved. So now that obviously subject to so many interpretations, but they always take it for the advantages, the government. So can you tell me more about this, that the interpretation of Constitution by the government at the moment?
See, I don't know if I would call it purposive interpretation. I think purposive interpretation, or the mischief rule of interpretation, is basically you're trying to interpret a piece of legislation or law from the point of view of, let's see what they were trying to do here. What was the purpose of the law? What was the mischief they were trying to get rid of? So to understand, to arrive at the true meaning of the law. In the context of, very generally speaking, in the context of, say, something like the abrogation of 370, I don't know, there was a journalist who used the term, and I think it pretty well describes it. I don't think it can be honored with purposive interpretation.
No, I meant the opposite of permanent. Like, that wasn't the purpose at the moment. And then that was my meaning, that opposite of purpose.
Yeah, I would rather call it constitutional sleight of hand. So you very, very likely what you've done is absolutely unsupported by any interpretation of the Constitution. but you are nonetheless invoking it to protect yourself with the protective covering that the Constitution affords you. So,
Yeah.
in fact, I would like a lot of the decisions. I'm not limiting it to any particular legislation or executive action, but a lot of the things that we've been seeing that the government is doing, it wouldn't be very far-fetched. At least my judgment is that the government possibly feels curtailed by the Constitution. Like the real sentiment may be somewhere that I wish this Constitution was not stopping me from doing this, because I would then have had a free hand in doing whatever I felt like. But because the Constitution and the manner in which our Constitution has grown and the way it was written provided for some guarantees. These guarantees are not easy to do away with, and these guarantees are coming in the way of the government from getting rid of them in toto, whole scale.
Yeah.
And I can just compare it with how I
Indira
feel
Gandhi.
during it is
Like, probably that was her logic was, right? It's like it's a problem and 42nd Amendment, things like that. And I think that is where Nani Palkiwala's argument, right? Like yesterday or day before was Kesav Nanda's Bharti case anniversary. And where he actually stated in Article 368, he emphasized on the word this. Very greatest.
I think the word stands amended. So basically, so I think, I don't know if this is what you're referring to. I think the argument there, the to and fro that was happening is that he says that the Constitution stands amended, right?
Yeah.
Stands amended implies that the Constitution continues to survive.
Yeah.
It doesn't mean that the Constitution goes away. So if you're saying that stands amended, it doesn't mean that you can, through your amending power, you'll get rid of the Constitution.
Yeah.
And he said, how ridiculous will be a situation where you invoke a provision of the Constitution that gives you the power to amend it, and you use that amending power to get rid of the Constitution.
Yeah.
And he says the word stands amended implies that this Constitution or its basic structure needs to survive your amendment.
Yes. Yeah, that's the thing. So also now coming to 370 general. So first of all, Article 370 was a temporary provision. And now I'm going to, sound like a very WhatsApp uncle. All right. And now you please, like, that's because no one asks the real question, right? So I'll tell you what obviously I'm a law student, I wouldn't say that, but in general, for what people say is that Article 370 was supposed to be a temporary provision. Article 370, the logic given by the government is economic development. So why shouldn't there be economic development? Anyways, any government that would have done it would have gotten resistance from the Kashmiris. So you can't necessarily blame this government, right? Any government in future, probably 20 years later, 30 years later, would have done it, would have faced resistance. So now you tell me, why is this wrong? I mean, like, why is abrogation of Article 370? Because there are two debates, right? One is whether abrogation of Article 370 was necessary, also how the abrogation was done. So that's the thing. So can you throw the light on both?
So I don't want to go into the legal arguments for and against to begin with. The matter is before court, and we will have hopefully soon there'll be an authoritative ruling on that. And I don't want to also say whether it was right or wrong, but I have questions, and I think and let's approach these questions for each of us to make up our mind as to what about it is probably correct, what about it is probably wrong. First is that Jammu Kashmir also had its own constitution.
Yes.
Right. And you also have an Indian constitution, which also to a large extent, based on how Kashmir adopted the Indian constitution or provisions of the Indian constitution to itself, became applicable. So there was a mechanism in place. The problem really starts is in identifying, like you said, whoever did it would face flack. Whichever government did it would face flack. Then the question comes down to how was it supposed to be done then?
Yes.
Right? And a large part of the question of the abrogation of 370 has rested with what was the role of the people who are either the beneficiaries of this move or the people who are going to be directly affected by this move, what was their role in it?
Yeah.
What was the average Kashmiris, the average resident of Jammu, the average resident of Ladakh? What was his or her role in this decision? Because finally, it is for their benefit.
Yes.
And the scenario becomes more suspicious. At least I'm asking this question. Agar karna hi tha, why did they do it? Why did it have to be done when there was an emergency in place?
Yeah. Exactly.
It's a state emergency. And during a state emergency, the legislative assembly is not speaking. And if the legislative assembly is according to our own constitution norms, the method through which there is representative democracy, I vote for my legislator represents me in the assembly.
Yes.
And if and when a decision has to be taken through the assembly, possibly my voice will be heard as to whether I'm for it or against it. What is to say that Kashmiris would not say that, yes, we want 370 to be abrogated? What is to say that they would have problems with it and say, no, you shouldn't do it?
Yeah.
But what was the effort made to identify that? And it becomes all the more problematic when it happens when there is an emergency in place, when the legislative assembly does not have a voice.
I'm really sorry I'm going into the legality of this, but is there any constitutional safeguard with regard to such slavish methods where, you put people in house arrest and then get this, or introduce something in the morning of and then pass it in the evening without giving the legislature proper time to, you know, deliberate? Is there any constitutional safeguard?
Well, I think that's the reason it becomes so much more important to go back to what you referred to as the Indira Gandhi time, as to when the basic structure was finally formulated, that idea itself. Just think of the things that are coming into question here. You're pulling into question our idea of federalism. What is
Yes.
the relationship between the union and its states? How are we dealing with the idea of representative democracy? Technically, if we accept what has happened in Kashmir to be all fair and correct, technically India can become, from a union of states, it can become a union of union territories.
Yeah.
Because you don't need to have any say, you don't have to even take the say of the legislative assembly. If a government wants to, and if this method adopted for the abrogation of
Yeah.
370 and the introduction of the Reorganization Act is correct, India can become a union of only union territories, where there is no federal aspect left in it. So
Yeah.
I see a big problem there. Second is representative democracy, where if the assembly and those houses that elect people to represent them are not going to be heard, are anyway going to be treated as mute spectators whose opinion or whose voice or will does not have to be considered, then what remains of representative
Yeah.
democracy? And that way, when we recently had a crisis in Bombay, Maharashtra could have become a union territory. Any place could have become a union territory. And when you think of it in
Yeah.
that scale, you realize that there is something off with the method in which they've approached this.
Yeah.
And even the debate in Parliament, if I recall right, the bill was passed and then the debate happened. So I don't know
Yeah.
if that speaks very highly.
Mr. P. Chidambaram gave a very moving speech where he said that he said, well, I'm speaking, I know it is not going to have any impact on the bill, but at least
Yeah.
what I'm speaking will exist in the records that someone spoke against it.
That's true, but there's another irony there, that there were, the Oxford Union conducted a debate where Jay Panda and Sitaram Yechuri were invited to speak on the abrogation, and this, I think, the debate was recorded sometime in October of
Yeah.
2019. And Sitaram Yechuri made a point, and he said that it's very ironic that to debate this in the Oxford Union there is no Kashmiri around, because they're all under lockdown. And if it is for the benefit of the
Yeah.
Kashmiris, I'm sure you should be able to provide for a scenario, a setting where the Kashmiri voice is also heard. And that is the reason I feel that expression, whoever used it,
Yeah.
constitutional sleight of hand, kind of captures the scenario pretty well. I don't know if it's constitutional, unconstitutional or not, but I
Yeah.
certainly smell something funny about it.
Yeah, that's it. And full disclosure here, Aditya is involved in the case with regard to 370. So we will not be able to go into the nuance because that case is still pending. Now, coming to the another major thing that happened last year was the CAA, right? There were so many protests and things like this. So question number one, can CAA be struck down just on the basis of the manifest arbitrariness doctrine? Because I think that's one of the most, like, I don't know, I would say fantastic, but interesting principles that have evolved and how it has evolved. So Justice Nariman in the McDonnell versus Andhra Pradesh case argued the doctrine of manifest arbitrariness, which was struck down. Then later, when he becomes a judge of the Supreme Court, he picks up that judgment, quotes that, and then uses it to, I don't know, like do a lot of legal changes, and then it was used in Section 87 of Arbitration Act, and then later things also. Yeah, Shaira Bano. Yeah, that was the major part. So now, can you tell me, just on the basis of manifest arbitrariness, can this be struck down?
Like, frankly, my view on this on the constitutionality of CA is, I believe it deserves to be struck down, and it can be struck down. Okay. But I very often, whenever the question of the constitutionality of CA comes up, I try and make it a point for us to take note of the fact that when we argue that the law CA is constitutional, we are almost making it sound like it's some great thing that it is constitutional. And I want to emphasize that constitutionality is a minimum test. It is the basic minimum standard that any legislation needs to meet. Yes. So by itself, in being held to be constitutional or otherwise, it's not like it becomes a very virtuous law. Yeah. Just to draw a parallel, before Section 377 was in the manner that it was struck down, read down by the Constitution bench, there was a fair amount of time for which Section 377 was thought and held to be very much constitutional, but it didn't make it a virtuous law. So constitutionality of the CA or the unconstitutionality, which the court will determine, only signifies that either the CA has achieved the pass mark in an exam or has fallen short of the pass mark. But it does not tell us anything about whether it is for the population a good law or for the population a bad law. So I think that, and that is the larger debate around something like the Citizenship Amendment Act. Yeah. And I really believe, so far as its constitutionality is concerned, which is yet to be decided, and we are very far away from getting into the depths of all of this through the court process, the fact that it strikes at our secular structure itself is reason enough to find problems with it, because we again are going into this idea of who a citizen is. And we are thinking of citizenship like the membership of a club, where there's a club that constantly keeps deciding who its members can become, who can become its members. But there's another way to look at it, which is that a country is not a club, and a country doesn't decide who its people are. It's the other way around. The people existed, the members already existed, and they decided that the club has been formed. And the club has been formed with these basic virtues, these basic values, of which a very core significant aspect is the fact that we are a secular nation. That in deciding who will be Indian and who will not be Indian, the uniqueness of your identity in terms of your religion will never be a aspect that either qualifies you or disqualifies you. Very recently I was walking and I got in Khan Market, and I got pulled into a television debate during the Delhi election. And one spokesperson or a representative of the BJP started like almost in a threatening tone to ask the people around.
Samit Patra.
What is so wrong with the CAA? And the only example I could think of then, and I don't know if it got finally carried into the program when it was telecast, I said this: look, think of all of us who are standing here and debating as people who are desperately hungry. Yeah. And we all, to satiate hunger, to feed ourselves with something, we walk across the road go to a restaurant and say, "Yaar, khana de do." He says,
Yeah.
"Yes, please, all of you come in. There's enough place. Place your orders." But there's waiting for the Muslims.
Yeah.
If there's a problem with that, if there's a problem with him saying Hindus, Christians, Sikhs, Jains, Buddhists, baki sab aa jao, khana order karo, we'll feed you. But the Muslims, there's waiting. Hold on for 6 more years.
Yeah.
If there's a problem in that, there's a problem in this.
Yeah.
Where your religious identity became the point at which you either got the benefit of something this country was offering or you were denied it.
Yeah.
And this is something you don't have control over.
No, but Aditya, now I'm trying to get a bit technical here. First of all, CA, to be very honest, it just makes the process faster for these religions from a specific number of countries from 11 years to 6 years. Number one.
6 years.
Number two, this logic of CA plus NRC doesn't make sense, because CA is with regard to citizenship by naturalization, and you can only be a citizen through naturalization if you're a legal immigrant. So if through NRC people are ousted of their citizenship, there is absolutely no way they can go through the CA path and get their process faster, because they don't have any way to show that I am from those countries.
So from the drift of your question, I get it that you're saying let's not mix NRC with CAA. Let's look at CAA on its own.
Yeah,
Okay,
because you cannot. Yeah. Now, so my first question here is, can India make country-specific laws? Because the intelligible differentia in the CAA, for example, if I am arguing from the state side, I will say, Your Lordships, the intelligible differentia is not the religion. The intelligible differentia is the countries they are coming from, because that is the point we made. So that is the first difference that we are making, that people from these countries. So is there a logic behind that argument? Can India make country specific laws like America? For Israel this is there, for Saudi this is the case.
So I think let's try and first settle on what the rule to be applied is. I think you're going back to the 1952 judgment. Asghar Ali Sarkar. I'm missing the name, but anyway, it's a 7-judge bench decision. And there is, what happened, and that's where they went into the test as to what finally the test to be applied is. Yeah. And there we came to one conclusion, that you're trying to first create you are trying to create a group.
Yes.
And you're trying to see what are the features of this group.
Yeah.
Is there anyone in this group, and you identified all the characteristics. With all these characteristics, is there someone being left out?
Yes.
Okay, so now this is a very rudimentary way of putting the test. Now let's just apply that to the way we see CAA. Let's not jump into judgment on whether it's good or bad.
Yeah.
The CAA is, after all, a law that amends the Citizenship Act of 1955 by creating 3 filters.
Yeah.
The 3 filters it applies is one of a test of date, which is 31st December 2014. It says that before this date, you must have come into India.
Yeah.
The second test it applies is that it says you should come from these 3 countries.
Yeah.
Right? And the third test and the third filter it applies is a filter of religion, saying A, B, C, D, E, F, religions can come in. This will apply to you. In other words, it's saying anyone but Muslim.
Yes.
Okay. Now, if these are the filters that you're applying, and the stated objective is that you want to protect people from religious persecution, which requirement itself is not there in any substantive portion of the Act. It is there in the Statement of Objects and Reasons.
Yes.
But let's test it against this. This law so it has made a group without explaining why the Muslims have been kept out.
Yeah.
Right? So then the first premise is religious persecution will not be faced by a Muslim if he is from a country that has Islam as its state religion. Can this statement be taken to be true? Can I vociferously argue that, let us say, a Bangladeshi writer who wrote novels about stuff that she found problematic with her identity as a feminist and
Yeah.
Islamic tenets in Bangladesh, forced her, and she felt persecution because of that, and forced herself to leave the country and come to India.
Yeah.
Will she be entitled to protection under the CAA? And how is she not part of this former group?
Yeah.
Then you need to have a justification as to why they need to be left out. Why does assume Taslima Nasreen was
Yeah.
wanted to take advantage of the CAA? What is the rational basis? What is your justification in your intelligible differential argument to say her kind need to be kept out?
No, but exactly that my point. That is my point. So they are not being kept out. They're only the procedures for certain people have been made faster. And these are
Why?
not my personal views. These are not my personal views. I'm just
I understand. I know
for the
you're
sake
arguing.
of argument. Yeah.
That's what I'm saying. So basically, when all of them went to dinner at that place, like I was saying, they were all equally hungry, equally persecuted. But the guy at the restaurant made a judgment call saying
Yeah.
that I value your persecution more than yours.
Yeah.
So you guys come in first. I will feed you. But sorry, there is waiting for you. You'll have to wait a little longer.
Yes.
And
Yeah.
what is the rational basis for that? And if
No
there is
rational.
no rational basis, and that is where I think it strikes
Yeah.
at being
Article 14.
reasonable.
Yeah.
It
Because
is arbitrary.
because test is there. No, so manifest arbitrariness is one test. That's the latest one. The original test is the nexus object and the whole test
and
that has been
whether
written.
the object itself is
Yeah.
it can be one of the state's objectives.
Yeah. That's fair.
Okay,
I-
so
yeah.
this being the thing, I don't see how you can balance it. I'm just asking myself, how do you
Yeah.
balance these scenarios out? And I don't see it. So maybe there is a very clear political shift also there, that
Yeah.
you want to convey a message that some people are more primary than others, some people
Yeah.
are more equal than others.
Exactly.
And
Also,
I
I
think
think
that's a problem.
yeah, in the international community, you want to say, we are the protectors of Hindus from and you come, we sit. Probably that is the message that you're giving off, right? Through this.
Yeah, and this actually came up in the Constituent Assembly debates also. So when they were debating Article 5 and 6,
Yeah.
there was a proposal that any Hindu or Sikh born anywhere in the world must automatically get Indian citizenship. Because the argument was that for Hindus and Sikhs, India is the most obvious and the only natural homeland.
Yeah.
And the Constituent Assembly, in its wisdom, did not pass that suggestion to say that we are going to peg citizenship or your right to be a citizen along with your religious identity. And I think we have survived this while with all our problems, only thanks to some of those wise decisions where we have tried to, at least on the face of it, maintain some distance from the state espousing one particular religion. But now if we get into that, then we are eroding everything that we knew of secularism and the way it's developed through even the court judgments.
Just a few minutes about NRC. Though a lot of people don't know. So NRC is essentially, first of all, the rules have only been made with regard to Assam. And one very interesting fact I recently discovered was that NRC was ordered by the Supreme Court of India.
Yes.
Yeah, and that is you see, I understand that the current regime might be totalitarian and things like that. But the thing is, now when I think about it, sometimes due to misinformation, there is so much confusion as people look at every decision microscopically, things will be a slightly different. Because if probably we should be blaming Supreme Court for the way NRC rules were drafted, number one. And obviously this administration wasn't properly done. And number two, my problem with the people in general is people have already challenged NRC on the anticipation for which rules haven't been drafted. Now, Aditya, tell me, if there is a seal of the Supreme Court which states no, it is legal because rules are not there. Now, the scope of challenge that could have been later to challenge it has also now been deterred. So there's a lot of idiocy. I don't know.
I'm hoping what you're saying will not be the case, and that if and when, I hope it never happens, but if and when it happens in the rest of the country, it will be looked at afresh without being influenced by previous orders that the Supreme Court might have passed for
that is
specific
true.
states.
Yeah,
but,
that's there.
Yeah, but we'll have to see. I think a large part of that debate will also be what exactly is there in the NRC.
Yeah.
So because I watched a very interesting movie recently. It's called
Tokyo
Mr.
Trial.
Klein. Mr. Klein. Have you watched it?
No,
so
no.
Mr. Klein
Sorry. Okay.
So it's this Mr. Klein is I think 1970s movie, and the plot is about a guy in France.
Yeah.
And his problem is that suddenly there's another guy with the same name who the authorities believe to be Jewish. And how they determine whether you're Jewish or not is by you have to go to an inquiry commission. And this inquiry commission will measure the width of your nose, the color of your eyes, your forehead, and determine whether ancestrally you're closer to being Jewish or being Christian.
Yeah.
Our man, he says, I'm Christian. But then he says, show me your papers. He said, I don't have papers, but I'm Christian. Dude, you've got the wrong guy. He says, okay, fine. The authorities say you've got 3 days time to show me your papers. And the one way for you to do it is to show that your parents are Christians, your grandparents are Christians. And they ask him to get his grandmother's papers, who was born in Algeria, France. So his test of showing whether he's a good Christian French citizen is going to depend on whether he's going to be able to get his papers. What happens to Mr. Klein is for you to watch the movie and figure out. But if that is not a movie and becomes reality, it's not going to be a very nice film.
Yeah, exactly. Also, full disclosure, once again, I work for this organization called Parichay. So I'm so it's, I don't know if you know, but they are filing appeals for the citizens who have been ousted in NRC in Assam. So I've been, so I'm actually part of the drafting committee. So we draft the appeals and things like that. Yeah, so it's very exciting. It's good because of the lockdown, relatively slow. And originally it was supposed to be 6 months, but probably now it will be a year. But I must say, like, it's very easy to make a law and, oust certain people. But it's very hard for them to get their freedom back. It's very hard. I want viewers to know, like, the kind of effort it takes. Even if you're doing good for 99 people, the effort that one person have to make to come into the latter categories a lot. Because I worked in Aadhaar judgment also. I worked on so many things, and you realize that every day, what is happening.
Okay.
All right. Anything else you want to talk about, say?
No, nothing. I'm very happy you're doing these podcasts. I'll watch the others you've done. I've not watched all of them. Okay. But if there's anything else you want to ask, I don't know. Maybe these are just my 2 cents on things. Yeah. Let's see how things shape up. And hopefully I'll have a chance to visit campus and do more teaching, which I've been very enthusiastic about, but I've not done much.
So most important question is, how does it feel to be doing your dishes and cleaning the house?
I'm very good at it. Okay. It's been cleaning, mopping, sweeping, and cooking. And I think generally I've gotten infinitely better at all of those. And I've also started valuing what our didis at home are, I think, who helped us with all of this did earlier. I've started valuing their labor even more.
Yeah. No, my Rubina is the perfect friend I have. All right, guys. Thanks a lot for Aditya. Like, genuinely, thank you for being there, because like we don't know each other personally also, but you were there, and thanks a lot.
No, that's great. Thanks a lot for having me on the show.
Yeah, and let's give a shout out to Jaideep so that he comes as a guest. I've been trying to get him. And
cool.
Yeah, all right, thank you. It's a wrap.
Okay.
थकेरा वो घुटनों पे आती नहीं सांस अभी देखे तो चारों ओर खड़े लपेटने को दानवी गलती की मुस्लिम है बंदा है मुजरिम में घर जाके फाड़ेगा मांस अभी उससे पहले मारे माता को जकड़ो उतरेगी इसी के खाने भी दुग्गी पे दुग्गी सत्ते पे सत्ता सोने की मुर्गी बना दी है सोने की चिड़िया बोले हम कुछ नहीं वो चाहते देशभक्ति मतलब चुप्पी बांधो सत्ता पे घुटने